Hello everyone, my name is Ursula Duran, and today I will be presenting the NYT v. Sullivan case brief for mmc4200. Section A. Case name and identification of the parties. NYT plaintiff versus Sullivan defendant. Full case name: New York Times Co. versus Sullivan. Citation: New York Times Co. v. Sullivan, 376 U.S. 254, 1964. Section B. Cause of action. Respondent L.B. Sullivan brought a suit in Alabama State Court alleging that he had been libeled by an advertisement in corporate petitioner's New York Times Co. newspaper. Section C. Facts. An action for libel was brought by L.B. Sullivan, the police commissioner in Montgomery, Alabama, against the New York Times, alleging that the newspaper published defamatory statements in a paid advertisement describing the police department's treatment, under Sullivan's supervision, of African American students protesting segregation. Sullivan argued that he was implicated in the false and defamatory advertisement because he oversaw the city police in his official capacity as police commissioner. Several of the allegations in the advertisement were false or exaggerated, while most were accurate. The jury awarded damages, and the Supreme Court of Alabama affirmed the verdict, stating the statements in the advertisement were libelous and not privileged, and evidence showed malice on the part of the newspaper. The case was then elevated by a writ of certiorari to the Supreme Court of the United States. Section D. Proceedings below. The Alabama State Court ruled in favor of Sullivan, finding that the newspaper ad falsely represented the police department and Sullivan. Sullivan's win was followed by an appeal from the New York Times to the Supreme Court of Alabama, which affirmed the lower court's judgment. The case was then taken by a writ of certiorari to the Supreme Court of the United States, where it was unanimously ruled in favor of the New York Times. Section E. Issues. Issue 1. Does the First Amendment of the U.S. Constitution protect libelous publications? Issue 2. Does a public official have to prove actual malice before he can recover damages in a defamation action against persons criticizing their official conduct? Section F. Holdings. 1. The advertisement at hand qualified for constitutional protection. 2. Established that statements under such circumstances against a public official must be proven to be false and made with actual malice or reckless disregard of whether it was false or not, before a public official can recover damages in a defamation action against persons criticizing their official conduct. Section G. Reasoning. 1. The United States Supreme Court ruled that the right to publish all statements is protected under the First Amendment. Therefore, whether the statements published in the full-page ad are accurate or false, they were protected under the First Amendment. 2. The public official could not prove that what was said in the ad against him was printed and published with actual malice by the newspaper. Therefore, the public official is unable to prove libel. Section H. Rule of Law. The United States Supreme Court held that the First Amendment needed a rule in place that prohibited public officials from recovering any damages relating to libel. Essentially, they ruled that unless the official can prove beyond a reasonable doubt that the statement was made and put out with actual malice, the publication cannot be held liable in an action for libel. Malice, as defined by the court, is the knowledge that the defamatory statement was false or made with reckless disregard for whether it was false or not. As someone who does not typically read over legal cases, understanding some of the legal jargon was a bit challenging for me. I feel this case sets an important precedent, especially during a time where news is constantly being questioned or or labeled as fake. In an attempt to be the first to break news or a story, it can be hard for a paper to verify everything they put out. I find the New York Times v. Sullivan case to be important because it protects the press and the public's right to criticize public officials in conduct of their duties. If the papers lived in constant fear of being sued for libel, we probably wouldn't have any papers left to read. Thank you for watching my case brief. I hope you enjoyed it.